All right, I need to tell you about something that happened at 6:47 this morning that most people are treating as just another court ruling. It's not. This is the moment when every procedural pathway, every delay tactic, every legal escape route that billions of dollars could buy just disappeared. Three federal judges. Unanimous decision. 8 hours from filing to complete rejection, and they used language that wasn't cautious or measured. It was absolute. If you want to understand the legal mechanics, not the political theater, but the actual constitutional machinery, subscribe right now, because what I'm about to walk you through is how accountability looks when the system finally activates. Let me take you through the timeline because speed tells you everything about argument strength. 11 p.m. last night, Trump's attorneys file an emergency application with the D.C. Circuit. They're asking the court to pause all proceedings while they appeal immunity questions to the Supreme Court. This is a tactic they've deployed successfully dozens of times. File emergency motions, create complexity, buy time, and courts, being deliberative institutions, typically respond carefully. They schedule briefing periods, they request responses, they hold oral arguments. The process unfolds over days or weeks. This morning, 6:47 a.m., less than 8 hours later, the court responds. Not with questions, not with requests for more briefing, with complete unanimous rejection. Per curiam. That's the legal term. It means the opinion comes from the court as a whole. No individual judge's name, no separate concurrences, no dissenting opinions, just the court speaking with one voice. When appellate courts issue per curiam opinions before sunrise on emergency applications, they're sending the clearest signal possible. Your arguments aren't marginally weak. They're so lacking in merit we don't need additional time. We don't need oral arguments. We don't even need to debate this among ourselves. The answer is no. It was always no. And it's so obviously no that we're telling you at dawn. Now listen to the opening language, because every word matters. Quote, former President Trump's alleged efforts to remain in power despite losing the 2020 election were unprecedented in our nation's history. Unprecedented. Courts don't use that word casually. In legal writing, it carries specific weight. It means this has literally never happened before. Not in 248 years. No president has done this. No court has addressed anything similar. The opinion continues. No version of presidential immunity, whether absolute or presumptive, was ever designed to shield a president from prosecution for attempting to obstruct the lawful transfer of power. No version. Not this interpretation fails. Not under these circumstances, immunity doesn't apply. No version. The court is stating that no reasonable construction of immunity could possibly cover what Trump allegedly did. When three judges use language like unprecedented and no version in a unanimous opinion issued at dawn, your legal strategy hasn't just failed, it's been systematically dismantled. And here's where this becomes critical. Trump has one move left. Appeal to the Supreme Court. 6 conservative justices, 3 appointed by Trump himself. Surely someone intervenes. 12 hours have passed since the ruling. Not one justice has issued a stay. Not one has requested briefing. Not one has given any indication they're touching this case. Complete silence, and that silence is an answer. The most definitive answer possible. We established the immunity framework. The D.C. Circuit applied it correctly. Your conduct falls outside any protection. We're done. Senator Lindsey Graham said it publicly yesterday. If the Supreme Court doesn't intervene, we could be looking at a criminally convicted nominee in 2024. A Republican senator acknowledging that his party's frontrunner may face conviction before the election. Here's what happens next, and this is where constitutional machinery becomes inexorable. The Speedy Trial Act requires trials to begin within 70 days once immunity appeals conclude. The D.C. Circuit just concluded them, unanimously. At 6:47 a.m., the 70-day clock starts when the mandate issues, when the full opinion is published. Legal experts expect that within 28 days, February 12th, then Jack Smith can demand immediate trial under statutory authority. Judge Chutkan cannot override. She already scheduled March 4th before these appeals. If the Supreme Court maintains silence, that date becomes reality. 70 days until Trump stands trial in federal court for attempting to overturn the 2020 election. And his legal team knows what's waiting. The witness list. Mike Pence, Trump's own vice president, testifying about every pressure campaign to reject electoral votes. Mark Meadows, Trump's chief of staff, describing meetings where Trump was explicitly told his plans were illegal. Pat Cipollone, Trump's White House counsel, recounting warnings Trump ignored. These aren't Democratic operatives. These are people Trump appointed, people he trusted, all testifying against him under oath. The evidence backing them, text messages, emails, phone records, January 6th footage the world has seen. Trump's team has reviewed this evidence. They understand how devastating it is. That's why they've fought for a year to avoid trial. Every immunity claim, every procedural motion, all designed to push past November, gambling that if Trump wins, he can terminate prosecution. That strategy died at 6:47 this morning. If this is valuable, hit that like button because Trump's response tells you everything. The Truth Social post started immediately. All caps, attacks on Judge Chutkan, claims of election interference, conspiracy theories. Then the post that triggered law enforcement alerts. If these witch hunts don't stop, our country will face problems the likes of which we've never seen. A former president facing prosecution for attempting to prevent power transfer is threatening problems if prosecution continues. Law enforcement is treating this as a credible threat, and Trump doesn't understand. Every post becomes evidence, every attack on the judge, every statement that could influence jurors, every comment that could intimidate witnesses, all archived, time-stamped, compiled by prosecutors building a real-time obstruction case. He cannot stop himself, and every word strengthens their case. Washington, D.C. reflects genuine threat assessment. Capitol Police at maximum alert. Security barriers around the courthouse. FBI monitoring communications. Joint Terrorism Task Forces activated. This is day one of a 70-day countdown. U.S. Marshals preparing enhanced protocols. Protective details for prosecutors, witnesses, Judge Chutkan. January 6th taught agencies never to be unprepared. They watched Trump's rhetoric become violence. They're determined it won't happen twice. Let me be precise about the charges. 4 federal counts: conspiracy to defraud the United States, conspiracy to obstruct an official proceeding, obstruction of an official proceeding, conspiracy against rights. Did Trump knowingly make false fraud claims? His own attorney general told him they were baseless. His own campaign lawyers said he lost. His own data team showed the numbers. Did Trump obstruct certification? The Georgia call, the pressure on Pence, the fake electors, January 6th. Did Trump conspire with others? The co-defendants, the coordination, the planning meetings, intent. That's what prosecutors must prove, that Trump knew it was wrong and did it anyway. The evidence of intent: recordings, testimony from advisors who warned him, documents showing he was told his plans were illegal. He proceeded anyway. When your own White House counsel tells you something is illegal and you do it anyway, that's intent, that's criminal knowledge, that's consciousness of guilt. The jury pool, D.C. 92.1% Biden voters. People who watched January 6th attack their city. Trump's team tried to move the trial. Every motion denied. But prosecutors aren't relying on political opinions. They're relying on evidence. When your own vice president testifies against you, when your own chief of staff recounts being told plans were illegal, when your own counsel describes warning after warning you ignored, political affiliation becomes irrelevant. Evidence matters. And here's what most people are missing. This isn't just about the D.C. case. If you think it has vulnerabilities, Georgia is waiting. Fani Willis, 19 co-defendants, State RICO, the recorded call. I just want to find 11,780 votes. Trump's voice, not disputed. The fake electors, forged documents submitted to federal officials. Georgia is state prosecution. Federal immunity doesn't apply. Federal pardons don't apply. Completely separate track. Florida adds a third jurisdiction. Classified documents, 32 counts, nuclear secrets, military plans, intelligence identities. Trump took them, kept them at Mar-a-Lago, allegedly showed them to unauthorized people. Evidence suggests he instructed staff to hide them from FBI. Surveillance footage allegedly deleted after subpoenas. If prosecutors prove Trump directed that deletion, that's obstruction carrying 20 years. This isn't one case. This is legal avalanche across 3 jurisdictions, each moving independently, each creating separate exposure. The Republican Party is fracturing, MAGA loyalists doubling down, establishment figures distancing. Internal polling shows 32% of Republicans won't support Trump if convicted. 32% makes him unelectable in a general election. Senate Republicans in swing states understand the math. A convicted felon at the top destroys down-ballot races. Stay loyal and lose. Distance yourself and maybe survive. Legal experts are saying what seemed unthinkable 6 months ago. Conviction before November is increasingly likely given the evidence. And if conviction occurs, federal sentencing follows. Trump has no prior record, normally mitigating, but his conduct during prosecution has been catastrophic. No acceptance of responsibility. Active obstruction, violated court orders, Witness intimidation, attacks on judges and prosecutors. Federal judges have broad discretion, and defendant behavior during prosecution heavily influences sentencing. Experts estimate 8 to 15 years if convicted on multiple DC counts, not maximum sentences. Realistic calculation based on how judges actually sentence obstruction cases with aggravating factors. Add Georgia. Add Florida. Even with partial concurrent sentencing, cumulative exposure could be 15 to 20 years. For a 78-year-old defendant, that's dying in federal custody. That's not hyperbole, that's mathematics. This is what Trump's team desperately tried to prevent. Because once trial starts, once evidence is presented, once witnesses testify under oath, no social media posting changes the outcome. The walls closed. This morning, at 6:47 a.m., unanimously, with no exits remaining. What's left is evidence in a courtroom, witnesses under oath, documentary exhibits, a jury deliberating, a verdict. The system designed to ensure no one stands above the law faces its most consequential test. A former president standing trial for allegedly attempting to prevent power transfer after losing an election. This has never happened in 248 years. Not because the system couldn't handle it, but because no president has allegedly done what Trump did. The precedent set in 70 days will govern American democracy for generations. If the system holds, if trial proceeds, if jury convicts based on evidence, it establishes that presidential power has enforceable limits, that consequences exist even for the highest office. If the system fails, it establishes the opposite, that wealth and political support can place anyone above law. That's what's at stake. Not just Trump's fate, the principle that law applies equally. 70 days. That's the window, until we find out which America we live in. Subscribe right now. Turn on notifications. The next development could break any moment. Drop a comment. Conviction before November. Realistic assessment? Share with someone who needs legal mechanics, not political narratives. The D.C. Circuit spoke at 6:47 a.m. unanimously. The Supreme Court has been silent 12 hours. That silence is deliberate. That silence is their ruling. No rescue coming. No immunity protection, no delay tactic remaining. What's left is evidence, and evidence leads to a courtroom, and in that courtroom a jury decides. 70 days, the clock is ticking, the trial is coming, and nothing can stop it. I'll see you in the next breakdown. Because it's unfolding rapidly, and you need to understand what happens when constitutional accountability mechanisms activate fully. The walls closed, the exits sealed, the countdown begun. And the American legal system is about to answer whether anyone, regardless of office or power, can truly place themselves above the law. This is not speculation. This is not theory. This is procedure operating exactly as designed. 70 days remain. The machinery is moving, and the outcome will define presidential accountability for generations. Stay with this story. This is the moment, and we're all witnesses to what happens when the system finally holds.